Mhm. You did mention about token, and maybe we'll dig more on the legal implications of token distribution and governance, because tokens really play a crucial role in DAO governance. Am I right? But their distribution and use, and it raises a question about regulatory compliance, particularly with securities laws. Now, understanding these implications is really vital for DAO sustainability. Without understanding this, I don't know if DAO would ever push through. Maybe you could elaborate, and can you elaborate on the legal implications of these elements, particularly in the context of potential securities regulations?
Yeah. So here we come to another problem, that the previous laws exist. So security laws were existing for a long time, and even DAO shall comply with all the regulations, even notwithstanding that they are very innovative, technological, and etc. And we can see it from the positions of SEC, CFTC, or even in European framework with their MiFID second and the recently adopted MiCAR, uh, money in crypto regulation. Uh, so yeah, uh, the DAOs that want to solicit any public, they shall remember about such laws and shall comply with them because, for example, SEC, they
Mm.
say that they have the extraterritorial jurisdiction over any company. So if you are trying to sell your tokens to US citizen, uh, SEC can fine you. Uh, the same situation with European Union. So every country, for example, if you are targeting the German auditory, the BaFin can fine you. So even though you are creating the company for your DAO or not, so you are going with an entity or entityless, you still can be fined because, as I said, if you are going entityless, your DAO can be viewed as a general partnership.
Mm.
Furthermore, with general partnership, all the founders they will be fined as a full with a full liability because it is not restricted by entity. Uh, Furthermore, we may talk about uh, different cases. It is a very important case, and the most well-known. It is the DAO order issued by Security and Exchange Commission, which says that the tokens, even not tokens, any cryptocurrency, uh, anything that is issued, for example, even NFTs,
Mhm.
it may be viewed as securities
Correct.
because if such token it undergoes through Howey test and it is concluded that all the four features are met, then such a token will be, of course,
Okay.
recognized as
Security.
a security.
Mm.
And uh, the main characteristic here is actually uh, do the members have a voting rights in DAO? But we shall distinct here voting rights because not all the voting rights actually uh, actually state that you had any rights to govern the company. For example,
Mm.
just voting in some polls, for example, which color our banner shall be, or which footer shall we use, or something like that. Actually, it shall not constitute the government's right, since you are not defining the direction of developing of business. So we can distinct here also. Not all the voting rights are governance right. Uh, and of course, if the DAO it pays dividends, for example, to its members, most likely it will be recognized as security in most jurisdictions. But actually, if it is possible for DAO not to be recognized as for DAOs tokens not to be recognized as securities if it doesn't give to if it is only a utility token, if it doesn't give the right to earnings, to share profits of the company, and even if it gives rights to govern the company, it can be not a security, since, for example, under the Howey test, the investor, he shall expect the investment returns from such investment. But if the DAO is non-profit, then there is no profits, there is no dividends.
Correct.
And the same works with European markets, where there is a financial instruments, and we shall apply the same for those markets. But we shall remember that Howey test is not appeal for European market, because there is other legal cases, other laws, and etc. So it is very important.